Judgment in the appeal of the Queen on the application of Champion and North Norfolk District Council and another.
Lord Cardworth will give the judgment to the court.
In October 2009, the Crisp Malting Group applied for planning permission to extend their operations by building 2 silos in a lorry park on a site close to the River Wensum in North Norfolk. The river is a special area of conservation protected by the European Habitats Directive. Under the Habitats Directive, consent could only be given if, after, quotes, appropriate assessment of any significant effects, the planning authority was satisfied that it would not adversely affect the integrity of the special area. Also relevant were the Environmental Impact Assessment, or EIA, Directive and regulations, under which the authority must carry out, quote, screening to decide if a proposal is likely to have significant effects on the environment. If so, EIA is required involving preparation by the applicant of an environmental statement and public consultation. At the time of the planning application, it was recognised that there was a risk of surface water runoff from the site polluting the river, and that further mitigation measures would be needed. In spite of that, the Council issued a screening opinion in April 2010 stating that environmental impact assessment was not required, and the application proceeded on that basis. Over the following months, the applicant submitted more detailed studies and mitigation proposals, which by January 2011 had satisfied the relevant authorities that the river would be protected from significant effects. Permission was eventually granted in September 2011 after a full report from officers on the technical issues and on the local objections. Mr. Champion, the appellant, is a local resident and a member of the Ryburg Village Action Group. His complaint is that the authority went wrong in law by deciding that it was unnecessary to carry out a formal assessment under either directive. He succeeded in the High Court, but that decision was reversed by the Court of Appeal. The Supreme Court unanimously dismisses the appeal in a single judgment given by myself. Dealing first with the Habitats Directive, there is no requirement for a separate stage of screening in any formal sense. It was enough that by the time of the approval, the planning authority and the expert consultees were satisfied that material risk of significant effects on the river had been eliminated. On the other hand, under the EIA procedure, authorities are in principle required to adopt a screening opinion at an early stage. As is now common ground, the Council's screening exercise in April 2010 was legally defective. The Council could not then be satisfied that mitigation measures would prevent a risk of pollutants entering the river. Although there is nothing in the regulation to rule out consideration of mitigation measures at the screening stage, they envisage that in cases of doubt, such measures should be included in an environmental statement and considered through the EIA procedure. That defect was not remedied by what followed. It was not enough that the potential adverse effects had now been addressed outside the EIA procedure. However, that is not the end of the matter. Despite that legal defect in the procedure, the Court retains the discretion to refuse relief if the applicant has been able in practice to enjoy the rights conferred by the legislation and there is no substantial prejudice. This is such a case. The only issue of substance related to the measures needed to protect the river. It is clear from the final report to the committee that the statutory agencies involved were satisfied on this issue and that the views of the public were fully taken into account. Mr. Champion has not been able to point to any specific concern that was not addressed before the final decision.
The court's adjourned.